Hi, I'm Nick Gillespie with Reason TV. Today we're talking with Lawson Bader. He's the president of the Competitive Enterprise Institute, CEI, who have brought King v. Burwell to the Supreme Court. Tell us about the case and how it came to be.
The short version is it's not a constitutional challenge, the same way that NFIB was a couple of years ago. It's a statutory interpretation, which already sounds boring, frankly. But what it is we're asking the court to interpret a part of the original Obamacare law, which essentially allowed individuals to purchase insurance through an exchange established, and the phrase is, by the state. If they don't purchase through the state, then they get tax subsidies. And we are actually challenging an IRS rule which extended those tax subsidies to anybody who is on an exchange,
right.
federal
and so
or
this
state.
is in
the
plurality of states that go through.
There are 34 states
right.
that chose not to set up their own exchange, which is, I don't think, what the White House originally expected, which is probably where they got the incentive to change the rule.
One of the arguments against the interpretation you're pushing for is just that, come on, this is clearly when the law says it's an exchange established by the state, they meant, either the federal government or an individual state, and that this is kind of high comedy almost, and nobody can believe that the Supreme Court or lower courts have taken it seriously, both in this and in a related case.
Yeah. As
well, that's still kind of on hold. So how do you respond?
Yeah. Well, I mean, law says what it says, and one of the key parts is it's an exchange established by the state in Section 1311. If you go back to those Section 1311, it doesn't actually come back to a state. And what the argument is essentially that you're making is, well, Kathleen Sebelius, who was of course Health and Human Services Secretary, is in fact a state. And that's the part that sort of we get a little humor when we do that. The problem is, the court needs to look at what was actually said, and you got to go back and look at what was intended. And if you go back in the politics, and remember this is before Ted Kennedy died and all of that, that some of the original legislative history of Obamacare included some of these incentives, and those did not appear in the later version.
And
so
from what I understand, like an earlier version did talk about it as a broader base set of subsidies that whoever, whether it was the federal government or the state.
And then those weren't present by the time the final bill got passed.
So what happens if you guys prevail in King v.
Think of this as a domino. So if we win, what happens immediately is about 5 million people in 34 states no longer receive subsidies. That's the personal impact, obviously. Purely from an economic standpoint, what happens is in 34 states, those same individuals are no longer eligible to apply to deal with the individual mandate, and the employer mandate is another thing that goes away. So it's all linked. So employers, you remember, if they have one employee who's getting a subsidy, they are actually fined because of the employer mandate situation. So no employees with no subsidies, no employer mandate, no fine. It changes the economics of the insurance industry. An insurance market essentially implodes over a couple of years.
Neither Reason nor CEI was in favor of Obamacare. If anything, we both, I think, agree that state action in the healthcare market needs to be shrunk, not enlarged.
Right. Sure.
Part of this, though, independent of that, isn't part of this case and proceeding, or problems with it, is that you don't really want to pass sweeping transformative legislation with a very, very thin majority that's all in one party.
True, although I would actually argue, Nick, that the real reason we're doing it has nothing to do with Obamacare. That's just a vehicle. For us, the real issue is, does a federal agency have the authority and the power to essentially reinterpret and rewrite a law passed by a legislative body?
Okay, and that's the IRS.
The IRS
is getting...
The IRS
wait,
is not...
So you're saying that the IRS is not our friend?
The IRS is not our friend.
Yeah.
At least it's not your friend.
Right.
It's always my friend. But the IRS is essentially saying what Congress passed is not what we're going to actually interpret. And now you've got a separation of power problem.
But then didn't we have in NFIB, I mean, the case about the individual mandate, we essentially had the Supreme Court rewriting the law. So
welcome to the wonderful world of litigation, legal interpretation, and politics in Washington, D.C.
When will we find out whether or not you guys prevail in this?
Probably the end of June, maybe first week of July, which is the last week of the July.
What's your best guess? Do you think yes or no? And
my best guess is yes, 5-4. But I'm going to be honest that there are a couple things that came up in oral argument that made everybody sort of Kennedy being the key, as Kennedy's always the key one, but in this case it's a question of federalism that's come up, and is what the original Obamacare, was that actually coercive, and is what we are arguing coercive in of itself, and that's a bit of a twist on the federalism head, and so we'll see how Kennedy views that. But Roberts was silent. That was the big surprise of the oral arguments, is Roberts essentially said nothing on the merits. But I think we're going to win 5-4.
All right. Well, we will leave it there. Lawson Bader, president of Competitive Enterprise Institute, thank you so much. For Reason TV, I'm Nick Gillespie.